Villanueva v Castaneda. Facts: on November 7, 1961, the Municipal Council of San Fernando adopted Resolution No. 218 authorizing some 24 members of the Fernandino United Merchants and Traders Association to construct permanent stags and sell in the said place. A protest was filed and the CFI decided that the land occupied by the petitioners, being public in nature, was beyond the commerce of man and therefore could not be the subject of private occupancy. This decision was not enforced, for the petitioners were not evicted. In fact, the petitioners paid daily fees to the municipal government. On January 12, 1982, the Association of Concerned Citizens and Consumers of San Fernando filed a petition for the immediate implementation of Resolution No. 29, to restore the subject property to its original and customary use as a public plaza. Vicente Macalino required the municipal treasurer and engineer to demolish the stalls. Petitioners filed a prohibition with the CFI claiming that the disputed area was leased to them by the municipal government. The CFI denied the petition. Issue 1. The petitioners have a right to the said land held no ratio. There is no question that the place occupied by the petitioners and from which they are sought to be evicted is a public plaza pursuant to the previous case. It does not appear that the decision in this case was appealed or has been reversed. A public plaza is beyond the commerce of man and so cannot be the subject of lease or any other contractual undertaking. This is elementary. Indeed, this point was settled as early as in Municipality of Cavite vs Rojas, where the court declared as null and void the lease of a public plaza of the said municipality in favor of a private person. In Wyatt vs De La Fuente, it was held that the city of Manila could not lease a portion of a public sidewalk on Plaza Sta. Cruz, being likewise beyond the commerce of man. We rule that the petitioners had no right in the first place to occupy the disputed premises and cannot insist in remaining there now on the strength of their alleged lease contracts. They should have realized and accepted this earlier, considering that even before case was decided, the Municipal Council already adopted Resolution No. 29, declaring the area as the parking place and public plaza of the municipality. It is the decision in Civil Case No. 2040 and the said resolution of the Municipal Council of San Fernando that Respondent Macalino was seeking to enforce when he ordered the demolition of the stags constructed in the disputed area. As officer in charge of the office of the mayor, he had the duty to clear the area and restore it to its intended use as a parking place and public plaza of the municipality of San Fernando. Conformably to the orders from the court and the council. It is, therefore, not correct to say that he had acted without authority or taken the law into his hands in issuing his order. Neither can it be said that he acted whimsically in exercising his authority, for it has been established that he directed the demolition of the stalls only after, upon his instructions, the municipal attorney had conducted an investigation. To look into the complaint filed by the Association of Concerned Citizens and Consumers of San Fernando. There is evidence that the petitioners were notified of this hearing, which they chose to disregard. Photographs of the disputed area, which does look congested and ugly, show that the complaint was valid and that the area really needed to be cleared, as recommended by the municipal attorney. Since the occupation of the place in question, it has deteriorated increasingly to the great prejudice of the community in general. The proliferation of stags therein, most of them makeshift and of flammable materials, has converted it into a veritable fire trap, which, added to the fact that it obstructs access to and from the public market itself, has seriously endangered public safety. The filthy condition of the Talipapa, where fish and other wet items are sold, has aggravated health and sanitation problems, besides pervading the place with a foul odor that has spread into the surrounding areas. The entire place is unsightly, to the dismay and embarrassment of the inhabitants, who want it converted into a showcase of the town of which they can all be proud. The vendors in the Tayalipapa have also spilled into the street and obstruct the flow of traffic, thereby impairing the convenience of motorists and pedestrians alike. The regular stallholders in the public market, who pay substantial rentals to the municipality, are deprived of a sizable volume of business from prospective customers who are intercepted by the Tayalipapa vendors before they can reach the market proper. On top of all these, the people are denied the proper use of the place as a public plaza, where they may spend their leisure in a relaxed and even beautiful environment, and civic and other communal activities of the town can be held. The problems caused by the usurpation of the place by the petitioners are covered by the police power as delegated to the municipality under the General Welfare Clause. This authorizes the municipal council to enact such ordinances and make such regulations, not repugnant to law, as may be necessary to carry into effect and discharge the powers and duties conferred upon it by law, and such as shall seem necessary and proper to provide for the health and safety, promote the prosperity, improve the morals, peace, good order, comfort, and convenience of the municipality and the inhabitants thereof, and for the protection of property therein. This authority was validly exercised in this case through the adoption of Resolution Number 29, by the Municipal Council of San Fernando. Even assuming a valid lease of the property in dispute, the resolution could have effectively terminated the agreement, for it is settled that the police power cannot be surrendered or bargained away through the medium of a contract. In fact, every contract affecting the public interest suffers a congenital infirmity in that it contains an implied reservation of the police power as a postulate of the existing legal order. This power can be activated at any time to change the provisions of the contract, or even abrogate it entirely, for the promotion or protection of the general welfare. Such an act will not militate against the impairment clause, which is subject to and limited by the paramount police power. Republic v. Gonzalez. Facts: the Republic of the Philippines is the owner of 2 parcels of land situated in Tanang, Malaban, Metro Manila. This piece of property was formerly a deep swamp until the occupants thereof, among them appellants Policarpio Gonzalez and Augusta Josue, started filling it. On April 14, 1955, then President Ramon Magsaysay issued Proclamation No. 144, entitled Reserving for Street Widening and Parking Space Purposes Certain Parcels of the Public Domain. Lots 1 and 2 were specifically withdrawn from sale or settlement and reserved for the purposes mentioned in the proclamation. The municipality of Malaban passed resolution authorizing the filing of ejectment cases against appellants. Separate complaints were then filed against them. Appellants disputed the right of the government to recover the lot, as the already filed sales application with the Bureau of Lands, he had a municipal permit to construct buildings thereon. The lot occupied was not needed to widen the street, and that the setting aside of the lots for parking space purposes does not redound to the public benefit. The trial court ordered appellants to reconvey the property to the government. Issue 1. Proclamation 144 is invalid. Held yes. Ratio: Proclamation No. 144 was issued by then President Ramon Magsaysay in response to several resolutions passed by the Municipal Council of Malaban, Rizal, which had become particularly aware of the increasing vehicular traffic and congestion along F. Sevilla Boulevard. The Municipal Council had proposed to widen F. Sevilla Boulevard and at the same time, to reserve an area for parking space to ease up traffic problems, in anticipation of the completion of the then proposed market and slaughterhouse located to the west of F. Sevilla Boulevard. In this day and age, it is hardly open to debate that the public has much to gain from the proposed widening of F. Sevilla Boulevard and from establishment of a municipal parking area. Indiscriminate parking along F. Sevilla Boulevard and other main thoroughfares was prevalent. This, of course, caused the buildup of traffic in the surrounding area, to the great discomfort and inconvenience of the public who use the streets. Under the Land Transportation and Traffic Code, parking in designated areas along public streets or highways is allowed, which clearly indicates that provision for parking spaces serves a useful purpose. Appellants, however, allege that the benefits, if any, that may be derived from the proposed street widening and parking space will be confined to people who have cars, hence there would be lacking the essential feature of property reserved for public use or benefit. The conception urged by appellants is both flawed and obsolete, since the number of users is not the yardstick in determining whether property is properly reserved for public use or public benefit. In the first place, Section 83 above speaks not only of use by a local government but also of quasi-public uses or purposes. To constitute public use, the public in general should have equal or common rights to use the land or facility involved on the same terms, however limited in number the people who can actually avail themselves of it at a given time. There is nothing in Proclamation number 144 which excludes non-car owners from using a widened street or a parking area should they in fact happen to be driving cars. The opportunity to avail of the use thereof remains open for the public in general. Besides, the benefits directly obtained by car owners do not determine either the validity or invalidity of Proclamation No. 144. What is important are the long-term benefits which the proposed street widening and parking areas make available to the public in the form of enhanced, safe and orderly transportation on land. This is the kind of public benefit envisioned by the Municipal Council of Malabon, Rizal, and which was sought to be promoted by the President in issuing Proclamation number 144. We believe and so hold that Proclamation number 144 was lawful and valid. Proclamation number 144 specifically provided that the withdrawal of lots number 1 and 2 shall be subject to existing private rights, if any there be. Prior to the issuance of Proclamation number 144, appellants had applied for miscellaneous sales applications over the lots respectively occupied by them. Insofar as appellant Policarpio Gonzalez is concerned, it is not disputed that he had acknowledged the ownership of the national government of the land applied for by him. The miscellaneous sales application, however, of appellant Policarpio Gonzalez had not been approved by the Bureau of Lands at the time Proclamation number 144 was issued. The land therefore retained its character as land of the public domain. Upon the other hand, the miscellaneous sales application of appellant Augusto Josue had already been rejected in an order of the Director of Lands dated January 8, 1954. Appellants allege having built mixed residential and commercial buildings on Lot 2. The evidence of record discloses that appellants had secured the appropriate municipal permits or licenses therefore, that is, for the construction of said buildings as well as the carrying on of business therein. However, since the lease, sale, or any other form of concession or disposition and management of lands of the public domain was directly under the executive control of the Director of Lands, and not of local government officials, the Malabon municipal mayor must be held to have exceeded his authority in allowing the use of lands of the public domain to appellants by constructing thereon commercial and residential use buildings, or any other kind of building for that matter.